everyone. You are on your daytime update. The National Prosecuting Authority saying it will oppose convicted child rapist Nicholas Ninow's leave to appeal. Ninow is expected back in the High Court in Pretoria on Friday, sentenced to life imprisonment for rape with an additional 5 years for the possession of an illegal substance and defeating the ends of justice. For more on that, I'm joined by Ulrich Roux in our studios now. Ulrich, it's good to see you.
Good afternoon. Thank you for having me.
Overwhelming evidence, Ulrich, that was presented. Even with the plea bargain, the court's going out to say, we don't believe your version of the story. Now, Nicholas Ninow is appealing both sentencing and conviction. First and foremost, is it out of the ordinary that the courts would admit this kind of appeal?
No, not at all. He is entitled to bring an application for leave to appeal, so that is his first step. He has to go back to the same judge that convicted him and that sentenced him and ask that judge for leave to appeal. Now, the test that the judge needs to apply is whether there is substantial and compelling evidence which shows that a higher court could come to a different conclusion, and that is the only test. So if the judge applies all the facts of the matter as well as the principles pertaining to sentencing in our criminal courts, and those were presented to a higher court, in this instance it would be to the Supreme Court of Appeal in Bloemfontein, is there a possibility that that court could reach a different conclusion? If the court finds that there is, then they will grant him leave to appeal, and then he has to appeal to the higher court in Bloemfontein. If it doesn't, then the court will reject his application for leave to appeal. It will be dismissed, and then he would have an opportunity to lodge a petition to the Supreme Court of Appeal, which is basically a written document that asks the Supreme Court of Appeal to look at the facts, look at the merits of the matter, look at the sentence that was handed down, and then determine whether they are willing to hear his appeal in that court or not.
So, I mean, ultimately, there is a guilty plea already on the table, and of course, by his version is that he was in the bathroom already taking drugs and therefore was not in control, even though medical experts, professionals have come to say he was absolutely competent, he was in his right mind, he knew exactly what he was doing as he was committing the crime, and the lawyers of Nicholas Ninow wanting to convince the judge to say you were supposed to have taken into consideration the fact that he was not really in control. Does he really have a leg to stand on?
I must say that I do find it quite bizarre that he's appealing his conviction, given the fact that he pleaded guilty. He pleaded guilty, but the state did not accept his version of the events. The state accepted the fact that he pleads guilty to the crimes that he was accused of, but the state said that he had misrepresented to the court what the actual events were and what the lead up to that was. So I would say that his chances of being granted leave to appeal his conviction are very slim to none. As you say, there was quite compelling evidence presented which shows that he at all times knew what he was doing, regardless of the fact that he had used drugs earlier that day. The sentencing one could have a look at. He has been sentenced to life imprisonment, which is the harshest sentence that a person can receive. It is a minimum of 25 years imprisonment. He will not qualify for parole. He also received 5 years for defeating the ends of justice, and that he tried to hide evidence from the police. There was also the scene at the Dross bathroom where he lied to the police, he prevented people from entering, all of that, as well as being in possession of unlawful substances, the drugs that he was in possession of, another 5 years. The sentence has been ordered to run concurrently, which means that it's not 35 years in total, it is 25 years in total, his life sentence. So it's not in addition to the life sentence he has already served. Once again, he would have to show substantial and compelling circumstances as to why or how a higher court could deviate from that sentence. So I would be interested to see what the grounds for his application for leave to appeal are. I do think that the conviction will never be set aside. One could possibly look at the sentencing.
So we were having a conversation earlier on amongst the team, because this sentence was handed down in October last year, as to how much time from conviction and sentencing can one actually appeal.
Well, if he did not lodge his application for leave to appeal within 30 court days, then he would have to apply for condonation for the court to accept that application for leave to appeal. I'm not certain whether he did. All we know at the moment is that the court will be hearing his application on Friday. So it could very well be that he lodged it within the required time, the 30-day period, and that the court has set it down for this coming Friday for argument to be delivered to the court. What would have happened is that his legal team would have had to serve the application for leave to appeal both on the court as well as on the NPA, and then the NPA would have an opportunity to either oppose it or say, well, we leave it in the courts of the hands of the court. The NPA has indicated that they are opposing his application for leave to appeal. So arguments in this regard will be heard on Friday. But yes, essentially to answer your question, you have a 30-day period within which to lodge that application for leave to appeal.
Ulrich, appreciate you. Thank you for coming through and clearing these matters for us.